The Commonwealth versus Lindsay Clancy will be an eye-opener for mental illness. Most people don't get it. For many, it's unfortunately still a stigma. And the question, was very interesting that was raised in court today. Here it is. Should the jury be able to hear from ordinary people like you and me about their personal experiences with mental illness and, in particular, postpartum depression, or being over-medicated, or hearing voices, or their experience in a mental hospital like McLean Hospital, where Lindsay Clancy was hospitalized? Well, this is such a unique case. And defense attorney Kevin Reddington wants to put on 16 women to take the stand and testify about their personal battles with postpartum depression and postpartum psychosis. So let me ask you, do you think that should be allowed? Would you want to hear from people who may have also heard voices and gone into severe psychosis if you were a juror? Jurors will be facing a challenge in this case. They must decide whether Lindsay Clancy was a cold, calculating killer or a mother whose mind had become compromised by overmedication and severe postpartum depression, that the law says she can't be held criminally responsible for the fatal injuries that she committed upon her 3 young children. This case is a tragedy. Well, welcome to the Margaret McLean Show. I'm a former prosecutor, civil trial attorney, and law professor. And this is where we take legal stories dominating the headlines and translate what is actually happening inside the courtroom. So please subscribe and press the like button, turn those notifications on, and I'll be following this case daily. It's actually occurring in my own county, not very far away at all. Jury selection begins next Monday, July 20th, 2026, and it's already a chess match. And between these two, the lawyers are great. The prosecutor is very good, and Kevin Reddington, the defense attorney, is one of the best we have in this state. So also, I have a live show every single weekday at noon called Lunchtime Law, where I will be reviewing this case, and I'll likely be talking about others as well, but this is going to be my primary focus of the week. Now, before we dive into this particular issue, let me give you a rundown. On January 24th, 2023, emergency responders were called to a home on Summer Street in Duxbury following a severe medical emergency. So Patrick Clancy had returned home to find his wife, Lindsay, critically injured on the ground after jumping from a second-story window in their home. So then he ran inside the house, frantically worried about the children. And in the basement, he found Cora, Dawson, and baby Callan. And he discovered that they had suffered fatal injuries. Cora and Dawson passed away that evening, and Callan passed away several days later. Now, Lindsay Clancy, the mother, was a labor and delivery nurse, and she survived the event, but was left paralyzed and wheelchair bound. Now she faces 3 counts of first-degree M. And the central question for the jury is not who was responsible for this tragedy, because Clancy admits to the facts surrounding the fatal injuries that she committed with, believe it or not, exercise bans. It's going to be brutal testimony, brutal evidence, but it's her mental state that's on trial here. Was she criminally responsible for those crimes? The state argues that these were calculated, intentional, planned acts of first-degree M. The defense maintains it was the direct result of severe postpartum psychosis and a medical reaction to a revolving cocktail of heavy prescription medications. And she was on quite a cocktail. She was on a lot of meds. Now, as I mentioned before, defense attorney Kevin Reddington attempted to bring in 16 lay women, strangers with no connection to the case, but they would testify about their personal battles with postpartum psychosis. He wanted them to look jurors in the eye and say, you know what? I heard voices just like this. I was over medicated just like Lindsay. I went into severe psychosis. I was absolutely out of my mind. So the prosecution objected. And why is that? I'll break it all down. It's actually a very good learning experience. It's something I would like to teach in my classes. But first, let's take a listen to Attorney Reddington's argument on this issue. So let me put him up here. Take me down.
Well, mighty and strong, we have many beers, and we're real quick to say, throw away the key on it. But a woman who has suffered and has put up with this affliction should be able to testify and say, probably in an emotionally charged fashion, very credibly, I too have heard these command voices. I too acted on the command voices. I too have had insomnia. I too have had hedonism where I don't even care if I live or die. I have no emotion. I can't feel. I can't laugh. I can't love. I can't hate. And I think that that is important. Now, before I disclose the identity of these people, it seems to me that what I have to do is present the general legal issue to you as a preliminary gatekeeper almost, where you would say, hypothetically, I think upon sufficiency of proof, it is admissible. And I am inclined, you the judge, to allow that evidence before a jury, at which point I would then, of course, disclose the identity of the people with their knowledge and consent, their medical backgrounds, and the government could then send their cops out to interrogate them or intimidate them or talk to them or do whatever they want to do. But if they get on that witness stand, they have credible evidence to give. So it's a two-part. I can't really give their names and addresses without knowing. You may say, as a matter of law, it's not admissible. Somebody's individual experience with a narcotic, with a drug, with a disease or a defect is not admissible in a sense of the specifics of a trial. And if that's the case, then it shuts down the issue and that's the end of it. But I had to raise the issue preliminarily.
Thank you, Your Honor.
Okay, I wanted to just add, wait 1 second. I got to stop her. This is a teaching moment for me, okay? Before the prosecution talks or before she presents her side of the argument on the motion, I'm going to say the following thing. So this issue is lay witness versus expert testimony. Under the rules of evidence, lay witnesses are limited strictly to firsthand personal observation of the actual events of the case. A lay witness can only testify to what they personally perceived regarding the specific crime or the specific defendant. Like, for example, somebody can testify about their personal observations of Lindsay Clancy, but they cannot give a generalized medical or psychological opinion. They're not qualified to diagnose or to contextualize an illness for a jury. Now, expert witnesses are, in fact, permitted to give scientific, technical, or specialized opinions based on training and education. If you want the jury to understand the terrifying nature of postpartum psychosis, you must do it through a forensic psychiatrist with expert credentials. Now, the expert can testify about medical studies and clinical diagnostic criteria, but bringing in 16 random citizens to give emotionally charged testimony about their own medical histories completely violates these boundaries. So now let's hear what the prosecution has to say, and let's see if Kevin Reddington did in fact convince the judge to allow this lay testimony. So let's hear what she has to say. And again, they're both great lawyers.
And the lack of notice in 1 week prior to trial, but also defense counsel cites no rule of evidence that would allow for the admission of layperson testimony about these issues. He cites to the battered woman statute, but in that statute itself, it refers to expert testimony, not laypersons saying, I had this experience, so the defendant must have as well. And then I think what we come to is it becomes more prejudicial than probative in that say you allow 16 people to come in and testify to that, then the Commonwealth gets to rebut that with their own witnesses. Women who suffered from postpartum depression and psychosis, who did not kill their children, who locked themselves in a room to keep themselves from harming their children, who got in a car and drove away so they didn't harm their children. And so then it becomes a trial within a trial. And it's more prejudicial than probative. There's no rule allowing the admission. And it would delay the trial, in all honesty, because then we would be filing a motion for discovery on these witnesses, their medical records, having them interviewed by police, which would take time. So I would object to this motion.
I'd like to know who these people are that were locking themselves in rooms and getting in their cars to avoid killing or hurting their children.
Just go on Facebook, they're all over.
But isn't that the whole problem? I think what the Commonwealth is saying, that this isn't just a trial within a trial, it would be 16 trials within this trial. I understand the argument, especially the kind of comparison to the battered women syndrome, but as those cases develop, I'm sure Mr. Reddington may remember, as those cases that became more and more admissible, it really hinged a lot upon the testimony of experts. And in this case, I anticipate there's going to be experts that are going to talk about the reality of this postpartum depression and postpartum psychosis. So that's coming out. And these are testimony that will come from the experts, I think, on both sides. It doesn't seem like there's a question of whether or not postpartum depression or psychosis is real. I mean, all the experts seem to agree that it's real. So because of the ability to get the probative part of what those women would bring to the court, the experts can give that. So I'm going to deny the motion at this time. All right.
Okay, so put myself back up here. So obviously the judge sided with the prosecution under the principles that I explained, lay witness testimony versus expert testimony. So the judge said, listen, the experts can talk about psychosis and postpartum depression and the fact that sometimes people hear voices, but not layperson. It was a good try by Attorney Reddington. He probably knew before he made the argument that he would lose. So, and also I think it was interesting because I think that one of the reasons that the judge sided with prosecutors, because he stated that it would create a confusing trial within a trial. And he noted that medical experts, just can simply properly explain the reality of these conditions to a jury. I like the idea of the trial within a trial. And if you think about it, that's exactly what it would do. You would prolong this case for a very, very long time. So expert testimony it will be, and it will also ultimately come down to battle of the experts. So tomorrow, please join me at Lunchtime Law at noon for more on this case. We're going to be talking about what else came out in that preliminary hearing. So lots of good stuff, lots of teaching moments. And of course, in my opinion, jury selection is what it's going to be all about. So we're going to be talking about what's going to be on that questionnaire. So I will see all of you hopefully tomorrow. Subscribe, please, for me and turn those notifications on. And I appreciate you listening to the Margaret McLean Show. Have a great night.